A pleasant day, everyone. I am Zenaida Bantilan, Bistrom 3A, and today we're going to discuss the chapter 4 of the legal aspect in tourism and hospitality, which is the laws on partnerships and cooperations. This topic, we are expected to differentiate the various kinds of partnerships and cooperations and the responsibilities of partners and incorporators and identify the requirements in the formation and dissolution of partnerships and cooperation. So let's dive in. What is the law on partnership? According to Article 1767, by the contract of partnership, two or more persons bind themselves to contribute money, properties, or industry to a common fund with the intention of dividing the profits among themselves. So, a partnership is association of two or more persons to carry on as a co-owners of a business for profit. The partnership contract is based on trust and confidence. Hence, the fiduciary relation in a partnership stems from the principle of delectus personae, wherein no one can become a partner in a partnership without the consent of all partners. So, here are the advantage of forming a partnership. First, it is easy to form. Second, it improved growth possibilities. And third is its freedom from bureaucracy. So the disadvantage of it is first is instability. Second is difficulty in obtaining large sums of capital. Third is the firm is tied to the act and judgment of one partner as agent. And lastly, it is difficult in severing partnership ties. Classification of partnerships. There are three classifications of partnership. The first one is according to subject matter. And the first type of it is the universal partnership, where all of the partners contribute all of their properties to the common fund and speaks of no particular purpose or subject matter. The second one type of it is a particular partnership. A particular partnership has for its object determinate things, their use or fruit, or a specific undertaking, or the exercise of a profession or vocation. The second classification of partnership is according to liability. And the first type of it is the general partnerships, composed of general partnerships where liabilities extend to their personal properties. And the second type of it is the limited partnerships, which one formed by two or more persons having as member one or more general partners and one or more limited partners, where the liabilities of the latter to the third persons is limited to their capital contribution. Now, the last classification of partnership is according to duration. And that type of it is the partnership for a fixed term is one in which the term of its existence has been agreed upon expressly, or as when there is a definite period, or impliedly as when a particular enterprise or transaction is undertaken. The expiration of the term thus fixed, or the accomplishment of the particular undertaking specified, which will cause the automatic dissolution of the partnership. Dissolution and winding up of a partnership. According to Article 1830, dissolution is caused first without violation of the agreement between the parties. A. By the termination of the definite terms or particular undertaking specified in the agreement. B. By the express will of any partner, who must act in good faith when no definite term or particular undertaking is specified. C. By the express will of all the partners who have not assigned their interest or suffered them to be charged for their separate debt either before or after the termination of any specified term or particular undertaking. D. By the expulsion of any partners for the business bona fide in accordance with such power conferred by the agreement between partners. Second, in intervention of the agreement between the partners where the circumstances do not permit a dissolution under any provision of this article by the express will of any partners at any time. 3. By any event which makes it unlawful for the business of the partnership to be carried on or for the members to carry it on in partnership. 4. When a specific thing a partner had promised to contribute to the partnership perishes before delivery, in any case by the loss of the thing, when the partner who contributed it, having reserved the ownership thereof, has only transferred to the partnership their use or enjoyment of the same, but the partnership shall not be dissolved by the loss of the thing when it occurred after the partnership has acquired the ownership. Therefore, 5. By the death of any partner. 6. By the insolvency of any partner or of the partnership. 7. By the civil interdiction of any partner. And 8. By the decree of court under the following article, which is the 1700A and 1701A. And according to Article 1831, on the application by or for a partner, the court shall decree a dissolution whenever 1. A partner has been declared insane in any judicial proceeding or is shown to be of unsound mind. 2. A partner becomes any other way incapable of performing his part of the partnership contract. 3. A partner has been guilty of such conduct as tend to affect judicially the carry on of the business. 4. A partner willfully or persistently commits breach of the partnership agreement or otherwise so conduct himself in matter relating to the partnership business is not reasonably practicable to carry on the business in partnership with him. 5. The business of the partnership can only be carried on at a loss. And 6. Other circumstances render dissolution equitable on the application of the purchaser of a partner's interest under Article 1813 or 1814 after the termination of the specific term or particular undertaking, and 2. At any time the partnership was a partnership at will when the interest was assigned or when the charging order was issued. Order of liquidation for general partnerships. According to Article 1839, in settling accounts between the partners after dissolution, the following rules shall be observed subject to any agreement to the contrary. The liabilities of the partnership shall rank in order of payment as follows. A. Those owing to creditors other than the partners. B. Those owing to partners other than for capital and profit. C. Those owing to partners in respect of capital, and D. Those owing to partners in respect of the profit. Now, for the order of liquidations for limited partnerships. According to 1863, in settling account after dissolution, the liabilities of the partnership shall be entitled to the payment in the following order. 1. Those to creditors in the order of priority as provided by law, except those to limited partners on account of their contributions and to general partners. 2. Those to limited partners in respect to their shares of the profit and other compensation by way of income on their contribution. C. Those to limited partners in respect to the capital of their contribution. 4. Those to general partners other than for capital contribution. 5th. Those to general partners in respect to profit, and 6. Those to general partners in respect to capital. Let us all move on to the law on corporation. In Section 2, corporation was defined as an artificial being created by operation of law having the right of succession and the power, attributes, and properties expressly authorized by law or incident to its existence. In the Philippines, the law which governs the creation of private corporation is Batas Pambansa BLG 68, known as the Corporation Code of the Philippines. The right of succession means that a corporation has the capacity to exist regardless of the death, withdrawal, insolvency, or incapacity of the individual stockholders and regardless of the transfer of interest or shares of stock. The power of all corporations are limited to those mentioned in their charters or in the General Act under which they are created. Kinds of corporation. The first one is the stock corporation, one which has a capital stock divided into shares and is authorized to distribute to the holders of such share or dividends or allotment of the surplus profits. A stock corporation is organized for profit. The governing body of the stock corporation is usually the board of directors. Second one is the non-stock corporation, one where no part of its income is distributable as dividends to its member, trustees, or officers. Subject to the provision of the Code on Dissolution, a non-stock corporation is one not organized for profit. The governing body is usually the Board of Trustees. Third one is the corporation de jure, a corporation organized in accordance with the required of the law. And the fourth one is the de facto corporation, a corporation which where there exists a flaw in its incorporation. The fifth one is the public corporation, one formed or organized for the government of a portion of the state. It is created by its own charter of the exercise of the public function. Example of this is barangay, city, and municipality. Sixth is the private corporation, one formed for some private purposes, aim, or end. It is created by incorporation under the General Corporation Law. This includes a government-owned and controlled corporation, which is an original charter, and quasi-public corporation, a private corporation performing public function. The seventh one is the corporation sole, one organized for the purpose of administering and managing as trustee the affairs, properties, and temporalities of any religious denomination, sect, or church. In this corporation, there are only one incorporator. The eighth one is the Eleemostanary Corporation, one organized for a charitable purpose. And the ninth one is the Domestic Corporation, a corporation formed, organized, and existing under the law of the Philippines. And the last one, the 10th, is the foreign corporation. A corporation formed, organized, or existing under any law other than those of the Philippines and whose law allow Filipino citizens and corporations to do business in their own country or states. Now, the advantages of corporate organization. First is strong separate juridical personality. Second is limited liabilities to investors. Third is the free transferability of unit of ownership. Fourth, the centralized management through the board of directors. And fifth is the professionalism. And sixth is the easier to sell small amount of stock to raise capital. Now, the disadvantage of a corporate organization is first, extensive government regulation. Number two, double taxation. And three is the activities are limited by charter and various law. Distinction between a partnership and a corporation. First, a partnership is created by the agreement of the parties, while a corporation is created by law. Second, in the partnership, the liabilities of the partners, except limited partners, extends to their personal properties, while the liabilities of the stockholders in a corporation is limited only to the extent of the shares of stock subscribed by them. Third, in a partnership, when the management is not agreed upon, every partner is an agent of the partnership, while the power to do business and manage the affairs of the corporation is invested in the board of directors or trustees. Fourth, a partnership commences to acquire juridical personality from the moment of the execution of the contract of partnership, while a corporation commences its corporation existence only from the date of the issuance of the certificate of incorporation by the Security and Exchange Commission. Fifth, a partnership may be organized by only two persons, while a corporate is requires at least five but not more than 15 incorporators to organize. Sixth, a partnership has no right of succession, while a corporation has such right. 7. In a partnership, a partner cannot transfer his interest in the partnership without the consent of all the partners because partnership is based on the principle of diluctus personae, while in a stock corporation, a stockholder has the right to transfer his shares without the prior consent of the other stockholders. 8. A partnership may be established for any period of time stipulated by the partners, while a corporation may exist for a term for 15 years to be extended for another term not exceeding 50 years. And lastly, 9. A partnership may be dissolved at any time by the will of any or all of the partners, while a corporation can only be dissolved with the consent of the state. Dissolution of a corporation. Corporations are dissolved as follows. First, voluntarily by filing the proper papers with the Securities and Exchange Commission. No hearing is required if there are no creditors affected, but a hearing is required where creditors are affected. 2. Involuntarily upon verified complaints filed with the Securities and Exchange Commission upon notice and hearing and on grounds authorized by the law as in the following: A. Fraud or misrepresentation as to the paid up capital of the corporation. B. Ultra wired acts which are persistent despite SEC warning. Republic versus Security. C. Continuous inactivity of the corporation for at least 5 years. D. Refusal to adopt or approve by law. And E. Serious dissension in the corporation. Third, expiration of the terms of corporation. Fourth, shortening of the corporate terms under Section 120 of the Corporation Code. Fifth, failure to organize and commence business within 2 years from the date of issuance of certificate of incorporation. Or six is by legislative dissolution. Corporate liquidation. After the dissolution of the corporation, it continues to exist as a body corporate but only for the purpose of enabling it to settle and close its affairs but not for the purpose of continuing the business for which it is established. The liquidation of partnerships affairs shall be for a period of 3 years. A dissolved corporation cannot extend corporate life during the 3-year liquidation period by amendments of its articles of incorporation extended corporate terms. However, if a corporation has a pending case which it filed during the 3-year liquidation period and it is still pending after the said period, then the stockholders should meet and transfer all the rights of held that even after the lapse of 3-year liquidation period. The officers and directors of the actions to the trustee so that he can continue the case until its termination. Finally, it has been held personally defunct corporations are the proper parties in interest insofar as they may liable for the unpaid deficiency tax assessment made against the defunct corporation. And that ends our discussion.